SJC-11844, Roseanne Sliney v. Dominic A. Previte, Jr.
Mr. Durso, good morning.
Good morning, Mr. Chief Justice, members of the court. My name is Carmen Durso. I represent the plaintiff appellant in this appeal. With me is Mark Itzkowitz, who is the principal author of the brief in this matter. The main issue before you today is the applicability and the constitutionality of the retroactive provision of the Child Sex Abuse Statute of Limitations found in General Laws, Chapter 260, Section 4C, which was enacted on June 26 by Chapter 145 of the Acts of 2014. The plaintiff asks you to determine the law is constitutionally sound and applicable to her claim and to allow her to proceed with her case in the Superior Court. I'd like to address briefly some of the issues other than the constitutionality at this time. Roseanne Sliney was sexually abused starting at age 5 by her uncle until she was 14 years old. Not surprisingly, at about age 24, she developed symptoms which required her to begin a series of mental health hospitalizations, treatments which continue to the present. About that time, she began to remember some of the things, but not all, which her uncle had done to her. There was a family confrontation, as a result of which her uncle wrote a letter, which is contained in the record appendix on pages 13, 14, which cannot be read as anything other than a confession. Nonetheless, you will read in the defendant's brief that he vehemently denies the allegations set forth in the complaint. In 2011, Roseanne remembered for the first time that her uncle had brought her to other men who also sexually abused her. We have argued that this gave rise to a distinct cause of action under the 3-year discovery rule then in effect, because they are occurrences which are have distinctly different elements of proof from her uncle's individual acts of abuse, and if they were today prosecutable as crimes, they would be expressed in separate and distinct indictments. Even though we now rely upon the newly enacted version of Section 4C, we ask the court also to address this issue for 2 reasons. The new statute also has a discovery rule of 7 years, and in the unlikely event the new statute is found defective in some respect, we will preserve the issue under prior existing laws.
Now, if I could turn you back to the constitutional or to the pragmatic, what precisely is your claim? Is your claim that the appeals court abused its discretion in denying your request to send it back to the Superior Court for Rule 60? Is that what your claim precisely is? Or that we, having taken FAR, should do that, should send it back to the Superior Court for a Rule 60 hearing? Or is it your view that the Superior Court has a legal obligation to grant your Rule 60 motion and essentially try the case under the new statute?
Well, the order that I understood under which the court took this was that they were going to consider all of the issues, including whether or not the prior actions had been correct, but also to determine the constitutionality of the statute.
Well, obviously, if the statute's unconstitutional, we would not send it back to the
Certainly.
Superior Court. I'm just trying to get a sense as to what you want, what you would ask the order. I mean, assuming it goes as well as you hope, what is the order supposed to say? What's supposed to be the last line of our opinion?
The case is remanded to the Superior Court for such procedures as the court will entertain at that time.
And is it your view that the Superior Court would then have discretion as to whether to undo the judgment or would be required to undo the judgment?
I would hope that what the court would say is, because of the new amendment, the circumstances under which the judgment was originally entered in the Superior Court no longer exist. Under the present statute that's been adopted, the plaintiff is within the present statute of limitations, and the retroactive provision applies because she has not yet reached 53 years of age.
Now, would it matter, now this case, of course, the new statute kicked in when, just after the appeals court had issued its opinion, but before FAR had been decided. Would it be different if the matter was done a year earlier and we had denied FAR and the case was over? Would that matter, or could the same argument be made that the case should be reopened?
Well, Justice Bodford at the single justice hearing asked me essentially the same question. She said, why don't we just...
We think very well, we think all alike all the time.
She said, why don't we just dismiss this? You go back to the court, and if there's authority in the Superior Court to do this, why don't you just go ahead and do it? And I said at that time, what I believe is the correct answer, if there is a final judgment in place, then the Superior Court may not have the ability to reopen the case at that time, at least under the circumstances of the cases under which we were seeking to have it do that.
So you're suggesting the statute doesn't do this automatically?
No, I think the statute does. I think the problem is that there is the only way in which a defendant might obtain any kind of vested rights here, which would interfere with the court's ability to declare the statute appropriate, the retroactivity appropriate, would be if there had been a final judgment and all appeals had been exhausted.
So you mean like for other victims?
I'm sorry?
Other victims of abuse who've tried to bring claims and
No,
have not
I
succeeded?
mean for this particular
But what
plaintiff.
about for other cases?
I don't think it would make a difference to other cases.
In other
As
cases?
long as they did, oh, you mean if they had also had a final verdict, a final decision?
That's right. They're out of luck?
I think so.
Are they out of luck?
I'm sorry?
You think they're out of luck?
Well, I think that the constitutional cases suggest that you can't revive a case which has been through all to the end of all possible appeals. That's what it seems to say in some of the federal cases.
So they would be barred on a basis of what, res judicata, that it's already been adjudicated, even though the statute of limitations has since changed, and if they were to bring the case today, they'd be able to proceed?
Wouldn't they have an equal protection claim, or would they?
It may be that would be a
Because clearly, under the statute, if they hadn't brought anything, if a plaintiff had not brought any action,
You'd be in a better position.
she'd be in a much better position.
and when we so advise people under these circumstances, Your Honor. The problem here is whether or not, when there's a final judgment, the defendant has acquired a vested interest. The vested interest cases seem to suggest if there has been a final judgment and all appeals exhausted, then the defendant may in fact acquire a vested interest. Now, that's not what happened here, even though the defendant has argued for a position of one who has a vested interest. But the answer to your question and the Chief Justice's question is, some of the cases seem to suggest that. I don't like the outcome either. There may be other arguments to be made, but I think so far they haven't been made, and the present state of the law is difficult in that regard.
So suppose this case did get back to the Superior Court, would the judge there be in a position to say, well, you're back, but the release that you signed back in 91 precludes any further action on this case? Are you suggesting that the release has no legal significance if the case gets back?
Well, I'm suggesting the release has no legal significance in this proceeding, because the court there has never addressed that, and the only issue really which the defendant raises in that regard is a pleading issue which the court did not consider.
But I think I think Justice Hines is saying if it did go back, that would be open to the Superior Court to
Oh,
consider
absolutely.
on the merits, whether whatever might be true in other cases, in this case, the release bars your client from proceeding.
In other words, the statute doesn't undo releases.
Oh, no. No, the statute does not undo the release. There are other issues with regard to the release, and
Yes.
the Superior Court will certainly deal with them when we're prepared to deal with them. The only point we wanted to make in our brief is that what the defendant says about the release really should have no effect upon your judgment on these issues, because the Superior Court never made a judgment on the issues.
And you would say, I mean, sometimes questions of law, it doesn't matter which court it is, but you would say there are factual defenses, and, I mean, there's a whole lot of stuff that really needs to be in a trial court on that question anyway.
Well, there's a very specific thing. If you ignore everything else that we say about the process by which the release was obtained, there is the very simple allegation that the release provided for a $26,500 payment, and the allegation that that payment was never made. The defendant certainly understood that well enough to plead as a defense that in fact the payment was made. So there's a factual issue there that's going to have to be resolved at a minimum.
In terms of the sort of overall constitutionality of a statute that extends the limitation period from 3 to 35 years, you sent the Connecticut case recently, which I forget what that extended it a lot. But
It extended it to age 48.
But it was the second time it extended it.
That's correct. And
I mean, are there? Here's my question: are there any cases in which a court has said the size of the enlargement is so large that we think to apply that retroactively really violates due process, substantive due process?
I'm not aware of any case which has said that, and it's interesting to note that the criminal statute with regard to sexual abuse actually has a provision under which there may be no statute of limitations, but if you don't meet the particular requirements, then it's to age 43. So there are a number of different judgments which the legislature has made with regard to these kinds of things, and I think it is a legislative judgment. The 48 is conceptually not that much different from the 53. The Connecticut Supreme Court talked about that and why it was appropriate, and I think its reasons are the same as this court should consider.
Now, there are not many cases for which the defense of laches applies, but would you agree that when the statute of limitations is that long, that there may be circumstances in which the defense of laches would apply?
You know, there's an excellent discussion in the Connecticut case about laches, because laches was raised there, and the point which was made by the court is that laches is strictly an equitable defense, and that the decisions of that court, certainly, and decisions of other courts have been that when the legislature prescribes a specific time period, that the equitable defense should not be applied, because it is then be the court interfering with the legislature's judgment about the particular time period that's involved.
But that's always the case. There's always a statute of limitations.
Well, I recognize that, but there is a significant difference between an equitable defense and a legal rule, and the court makes the point that the equitable defense should not be interposed to interfere with the judgment of the legislature. All of the constitutional law with regard to this issue comes down to a recognition of the legislature's right in these circumstances to deal with a particular problem and to come up with a solution which is appropriate. And if indeed it's clear that the legislature's intention was to do that, and I think it's crystal clear because of all of the information we have in the record, that that was their intent, to make it retroactive for this period of time. Everybody understood that. Both branches passed this bill unanimously, that the court really has to defer to that unless there is a vested right which is harmed, and there is no vested right which is harmed in this case.
right, thank you.
Thank you.
Good morning, Your Honors. My name is Sylvia Katzinis, and I represent the defendant Dominic Previte. In March of 1991, the plaintiff, Roseanne Sliney, settled her remaining claims against Mr. Previte and executed a release. That release is in the record before the court. It was attached to the plaintiff's complaint. In this action, among other things, the plaintiff seeks to have that release voided or nullified based on certain grounds.
Yes, but not in this court, though, I think. Not by us. I think he would say, or she would say, that's
Well,
that's
it
for
was-
later.
The deficiencies in the pleadings with respect to the release were made part of our motion for judgment on the pleadings in the Superior Court.
But the judge didn't act on that basis.
He did not. He felt that the case, because the case was dismissed. But nevertheless, whether the judge acted on it or not, and it was before the appeals court as well, the appeals court did not act on it either, because, again, they decided the case on the basis of the statute of limitations. But nevertheless, this court is not bound by the actions, or limited by the actions of the Superior Court or the appeals court. It can still consider the matter of the release, and it very definitely should consider the matter of the release.
Let's assume we don't, and let's assume we want to focus on the statute of limitations issue,
To the main event.
to the main event.
Then-
This vesting of rights which you claim, how can one vest one's rights when there's still, the appellate process is still continuing, especially with regard to further appellate review having been now granted?
Your Honor, as the court is aware, in July of 2012, judgment was entered in the Superior Court dismissing this case based on the statute of limitations. That judgment was affirmed by the appeals court on December 31st of 2013. 6 months later, the Chapter 145 was enacted into law. Now, if the decision of the Superior Court was correct when it was made, that, or if I may back up a bit. Now, obviously, the decision of the appeals, of the Superior Court was subject to an appeal. But an appeal based on what? On the state of the law as it existed at the time that the decision was made. Not what the law was subsequently 2 years later, or what might be 3 years from now. And that is the case of Martell versus Moffett. I've cited in the brief 276 Mass 174, where they say the rights of the parties are determined according to the statutory practice in effect at the time of the decision of the judge, which is now under review, and not according to that which would be in force if such decision were to be made now.
But is the statute of limitations a right of a party?
It's a remedy. It's procedural. And procedural statutes are very often applied retroactively to pending cases. But there is a limitation to that doctrine of retroactivity. And the rule that has evolved in Massachusetts, and I've cited the cases, and it starts with Martell versus Moffett, is that if before the new procedure goes into effect, a pending case has gone beyond the procedural stage to which that procedure would pertain, then the new procedure is not applicable to that case. And that rule makes a lot of sense. Because, for example, what if this court...
Yes, but you've got Section 8 in this particular statute that talks about, doesn't matter when the claim was filed, doesn't, you know, I mean, it's an enormous retroactivity proceeding, which arguably applies exactly to this kind of situation, if the case is still pending, which this one arguably was.
Well, it doesn't say, Your Honor, and applies to cases still pending. It just talks about regardless of when the case was filed. It doesn't say, you know, and still pending, or it applies also to cases on appeal. Now, the legislature is presumed to know these cases that are out there.
But we also have pretty explicit legislative history.
I'm sorry,
We have pretty explicit legislative history also.
but it does,
That they intended to apply the extension retroactively to pending lawsuits.
certainly, but they don't say to pending lawsuits that are on appeal where the issue of the statute of limitations has already been decided. And the only question at that point is whether the decision of the Superior Court judge was correct. I would like to call the court's attention to the difference between the retroactive provision of Chapter 145 with the retroactive provision which occurred in the case of Pillage versus Massasoit Greyhound. And that statute said that it applied to all other claims pending before the Commission Against Discrimination, it was a discrimination case, or to a court on the effective date of this act, including claims upon which final judgment or judgment after rescript has not entered, or as to which a period to file an appeal, certiorari petition, petition for rehearing, or similar motion has not expired on said effective date. They hammer that point home, that it was going to apply to all these pending cases. Now, they did not do so in 145, and the reason may be because of the constitutional issues that are going to arise. Once you're getting very close to that constitutional third rail, once you start applying it to pending cases where a decision has already been made in the lower court and affirmed in the appeals court. Even if it hadn't been affirmed in the appeals court by the time 145 went into effect, the decision had been made in the Superior Court, and that's really the baseline right there.
So
Now-
if a judge, if the Superior Court judge, who's now retired and can't do it, but if he were not retired and said, golly, I've seen this new statute, I think it's unfair that two people in the same position are going to be treated differently simply because one chose to bring an action and one delayed bringing an action. So I'm going to basically, under Rule 60, even though I had just ruled in this case, I'm going to undo it and allow the case to go forward under the new statute. Would that be barred, or is it because the appeals court has ruled?
It would be barred because, getting back to the original argument that I was asked about the vested rights.
So when does the right vest? Does it vest upon the judgment in the Superior Court? Does
Correct.
it?
That's exactly
So
what
you're
it
saying the judge
vested.
could not do that? The judge could not undo the judgment?
Cannot undo it, because, as I said before, the decision of the Superior Court, if the decision of the Superior Court were correct when it was made, then there was at least a substantial likelihood that it would be affirmed on appeal. I mean, in theory, it should absolutely be affirmed if it's correct, but certainly a substantial likelihood that it will be affirmed on appeal. And if there is a substantial likelihood that a person who claims a right or a benefit is going to eventually enjoy that right or benefit, then that right or benefit is deemed vested for constitutionally protected purposes. And that's
So that means anytime an appellate court reverses a case, it has undone a vested right?
No, it depends on what the decision is. No, what
Well,
I'm saying,
could it ever be that an appellate court has undone a vested right through a reversal of a lower court
well, it
judgment?
depends on whether the decision of the lower court were correct or not.
Well, is that some platonic judgment about whether it's correct or not? I mean, isn't it the appellate court that under our system figures out whether it was correct or not?
Of course, that's absolutely correct.
I take it what you're saying is we have to first look to see whether the judge's decision was correct under the statute of limitations as it existed at the time the judge decision was made.
Absolutely.
And then, and if the answer to that question is yes, we
Yes.
don't look to the statutory amendment.
That's correct, that it's inapplicable at that time.
Does that change if the legislature was even more clear than it was here?
No,
That it's intended to apply to all matters, including any matters that happen to be on appeal and were decided under the prior statute of limitations?
I mean, if it had the
No.
PLOC language.
Are you saying
yeah,
even
well,
then?
PLOC,
Even then, it's not a it's a
was
vested right?
declared unconstitutional, and PLOC, now, I have to be clear, dealt with substantive rights rather than procedural rights here, but nevertheless, the statute was declared unconstitutional. And when you make something retroactive, it's got to be, at the very least, reasonable, even if there are no direct constitutional rights infringed by that statute.
And why is it unreasonable?
Well,
Why is it
we're
unreasonable
rolling-
to say, we think it's unfair that persons were denied their opportunity to reach a decision on the merits by the statute of limitations in these types of cases, and therefore, even if there had been an adjudication below, we're going to allow them to get to the merits? Why would that be unreasonable?
Well, first of all, we're rolling this cause of action back. This cause of action lapsed approximately 23 years before Chapter 145 went into effect.
So is it unreasonable because of its length, or is it unreasonable because it's retroactive?
Well, one of it has to be, when a statute is retroactive, it has to be reasonable. And it is obviously unreasonable to roll something back 23 years.
Well, it might be unreasonable if you're changing the standard of conduct retroactive to 23 years, but this was a tort 23 years ago as it was today, so the conduct has not been changed.
That's correct, and I'm not arguing the conduct here, but meanwhile, look at what's happened in that 23-year span.
I understand that, and that speaks to, I mean, because of course, putting your client aside, anyone who brings an action now, 35 years after the event, which the statute permits, the same question can be made. Well, how can I defend something that happened 35 years ago?
Absolutely.
So you're saying the legislature simply had no power to make a statute retroactive, or to put a 35-year statute of limitations on this?
Well, that's what I'm saying, that it's, and it's certainly unreasonable as applied to this case. Maybe it would be, unreasonable as applied to something
Well, your
else.
client faces the same challenges anyone else would face if someone brought a claim 2 decades after the fact.
Well, the further challenge my client would face is that release was notarized.
Oh, well,
Now-
the release is a very
well-
separate issue. I
well,
understand your issues about the release.
But it's intertwined with the statute of limitations, because now the plaintiff claims that she was coerced into signing it, she was fraud and duress. That release was notarized. We would bring the notary public in to testify as to the facts surrounding that
But there's
claim.
no statute of limitations for murder.
No, but
So is that unconstitutional for there to be no statute of limitations for murder? Can't the legislature say there are crimes so serious that we want there either to be no statute of limitations or a very lengthy statute of limitations?
Yes, but when you commit a murder, you know that there's no statute of limitations. When you roll something, when you expand the statute to such an extent.
But
Oh,
So it's the change here, not the time
Well,
makes it?
certainly the change. I'm not, and because of it's such a long period of time, again, would we reasonably expect the notary public to remember anything after all these years?
But you're not suggesting that the conduct was affected by the length of the statute of limitations, that the person would have said, well, I will commit this sexual assault knowing the statute of limitations is only 3 years, but
No.
I may have thought differently if it had been
No,
longer.
I'm not saying the conduct would change, but as I said, his subsequent actions may change, tossing out books and records which would perhaps show his whereabouts, show that he couldn't possibly have had the access to this woman
But
that she claims.
Wouldn't that have been also, I mean, this case was brought in January of 12, right? Well, let's say the statute at that time was 35 years, that you would have had the same problem, right?
Yes, but at least we would have known this statute had a 35-year term. So we would be more careful about keeping books and records, so on and so forth.
Okay, thank you.
Thank you, counsel.
Thank you, Your Honor.